All right, thank you so much. Good morning, everyone. As was said here, we're going to go through the sexual harassment prevention training provided by the Department of Human Rights. I am with Rogers HR Consulting, consulting firm that you guys use for this. I am not with a state agency, so um, please make a note of that. That is me. I've been doing this consulting for about a year and a half now, and I've been involved in human resources for most of my adult life. And so things like this are kind of near and dear to me, and I enjoy doing them, and I enjoy the opportunity to get in front of you folks and talk about these types of things. I am not an attorney. I'm just a consultant. I get some training from attorneys. I have a professional certification. My advice today is not legal advice, but rather just training. So let's get started with this. Um, Also, it was mentioned that a record of training is needed, and you don't have to have a certificate necessarily on file, but you need to have a record that shows um, that your staff has in fact attended this, and the name of the employee, the date, and you can keep these records electronically, or you can have them on paper, however you choose to do so. So you've got to stay online and participate for the full scheduled time to receive your certificate or to have this counted as participation. The state of Illinois is in the lead with employment regulations. When people talk about this, they often talk about the bi-coastal mentality where things start out in California, migrate to New York, and then on to Chicago, Atlanta, Dallas, and so forth. So last numbers that we had here said that 20% of the workers in the US are now required to be trained on harassment and discrimination prevention. 2 years ago, that was about 1%. So today, we're here to train employees on anti-harassment requirements for 2023 and beyond. The Illinois Human Rights Act makes it a civil rights violation for any employer or employee or agent of them or agency or labor organization to engage in sexual harassment. The Illinois General Assembly finds tolerance of sexual harassment as a detrimental influence in the workplaces by creating hostile work environments for employees, reducing productivity, and increasing legal liability. The state is encouraging employers to adopt and actively implement policies to ensure their workplaces are safe for employees to report concerns about sexual harassment without fear of retaliation, loss of status, or loss of promotional opportunities. The employers are required to provide sexual harassment prevention training for all employees. Every employee in the state of Illinois is required to provide. Someone asked me, how many employees do you have to have for this to be valid? And the answer is one. So, and it needs to comply with Section 2-109 of the Illinois Human Rights Act. All employees, regardless of their status, must be trained, and you have 90 days to get this done when you have a new hire on board. If an employer has an independent contractor working on site with the employer's staff, the independent contractor should have received sexual harassment prevention training. And you could probably accomplish that by just getting some documentation from a vendor. If you had a software vendor on site doing some training with you or helping you with an implementation, if you had some other contractors on site doing some work for you, it would behoove you to make sure that their folks have had this training, and if they haven't, then it's on you to make sure that it gets done. Okay, these are the points that we're going to cover today. We're going to go over an explanation of harassment consistent with the Human Rights Act, some examples of conduct that may constitute unlawful sexual harassment, a summary of some federal and state laws concerning sexual harassment, including some remedies available to victims, and a summary of employer responsibilities in the prevention, the investigation, and corrective measures needed to address the sexual harassment. So, what is sexual harassment? Under the Illinois Human Rights Act, sexual harassment means unwelcome sexual advances, requests for sexual favors, or any conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly as a term or a condition of individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions uh, affecting such an individual, or such conduct has the purpose or the effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. That's a lot, but understand that the terms of condition or employment are something that if you tell someone to get this job here, you have to do this. So employers sometimes get in trouble with certain documents. There's been arbitration documents employers have tried to have employees sign, and that's like a condition of employment. If you don't sign it, you don't get to work here. So you can't do anything like that. Sexual harassment really breaks down into two areas: the quid pro quo and the hostile work environment. Quid pro quo is the Latin, and I believe the exact translation is this for that. Um, you do something for me, and I'll do something for you. This means that a manager or supervisor may not tell an employee that in order to receive a promotion, raise, preferred assignment, or other type of job benefit, or to avoid something negative like discipline or an unpleasant assignment, the employee must do something sexual in return. Can't do that. That's overt, and that's going to cause big problems for your organization. And that's probably easier to identify than the hostile work environment. The hostile work environment is when the air is full of sexual references and it's impacting me. A hostile work environment may occur when unwelcome sexual advances, requests for sexual favors, or any other conduct of sexual nature has the purpose or the effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. Um, that's a lot to digest, and we'll talk more about that as we go through this here. Some quick examples: a quid pro quo. Mary Smith receives a smaller pay increase based on performance other than similar employees because she refused to go out with her supervisor, John Doe. In the hostile work environment, Mike Maloney is leering at and intentionally brushing against Sally Davis. Online, Jill Jones texts and in messages her coworkers with sexually explicit jokes and pictures. These types of things, at least in my mind, seem like they shouldn't be going on in the workplace today at all. But the line of work that I am in, I see this happen routinely. So don't stick your head in the sand and think that this isn't going on in the workplace. Perhaps not in your workplace, but in many other workplaces, these types of conduct are still going on, and they result in judgments against others routinely. Unwelcome behavior. Sexual conduct becomes harassment when the behavior is unwelcome. Behavior may be unwelcome in the sense that the victim did not solicit or invite it, or in the sense that the victim regarded that the conduct as undesirable or offensive. Welcome behavior can quickly become unwelcome behavior. What starts off welcome behavior, consensual joking, can cross a line and then it turns into unwelcome behavior. Consent can be revoked at any time. When someone's experiencing sexual harassment behavior, says, "Stop talking to me like this." The conduct needs to stop immediately. The perpetrator cannot use as a defense, "Well, you started it," or "You were okay with it at first." Anyone can stop this at any time and say that they're uncomfortable with the comments that are going on or the conduct. Um, the more subtle things are, I worked in a manufacturing environment where sometimes, it's very close quarters. So someone will be brushing up or pressing up against someone, and that makes them very uncomfortable. And we do need to make sure that our employees know that they need to say something if they are uncomfortable, that they need to speak up, and they don't have to be mean or rude or anything else. Just, "Dave, I'm uncomfortable with you standing that close to me. Could you please move away a little bit?" So make sure that everyone knows that. I think people sometimes do that in the office environment as well. If they're close to someone, they may put a hand on them or something like that. And that's the type of behavior that people become uncomfortable with very quickly. The employee's working environment. It is not just limited to their physical location where the employee is assigned. The working environment extends to other work sites, including off sites, mobile, moving work sites, locations, off-site meetings. For example, a working environment includes the courthouse for a lawyer or an off-site event for a caterer. So if you have off-site meetings or anything like that, that is the workplace as well. A couple people riding in a car together would be the workplace. So it doesn't have to happen just inside a particular facility. This conduct can take place just about any place to do with work. And I suspect you guys have people doing remote work, so that can be in the fray as well. Gender identity, sexual orientation, and third-party bystanders. All persons can be victims of sexual harassment regardless of their gender identity or the perpetrator's gender identity. All persons can be victims of sexual harassment regardless of the victim's sexual orientation or the perpetrator's sexual orientation. So this can be male on male, female on female, male on female, and bystanders. And this is probably a good time for me to mention that any of those of you folks who live or work in the Chicago area, there is an additional hour of training required about bystander intervention. This is directed at supervisors and managers, and just make a note of that. The association has provided that and said that we have folks who have provided that. A lot of agencies have their own programs for this as well, but make a note of that. Employees and non-employees as victims of sexual harassment. The Illinois Human Rights protects employees as well as non-employees from harassment. Employees include coworkers, supervisors, and managers. Non-employees include persons who are not employees but directly performing services for an employee, such as a contractor or a consultant, independent contractors, or even gig workers. Somebody playing the piano in a bar, even though they independent contractor, the bar has to be responsible for the conduct of the patrons there. Victims of sexual harassment can include employees and non-employees when sexually harassed by other employees or non-employees. Victims of sexual harassment can include not only the target of the sexual harassment, but also those employees or non-employees who are bystanders or witnesses to the sexual harassment. So that bystander thing is popping up again here. Customers or patrons as victims of sexual harassment. The Illinois Human Rights Act protects customers and patrons from sexual harassment in places of public accommodation, such as stores, hotels, restaurants, theaters, museums, health clubs, or even hospitals. Employers that are also places of public accommodation are responsible for harassment of customers and patrons when perpetrated by their employees or their non-employees. So anybody running any establishment is pretty much responsible for everybody there and their conduct. Employees and non-employees as perpetrators of sexual harassment. The Illinois Human Rights Act prohibits employees and non-employees from engaging in sexual harassment. Employees are coworkers, supervisors, and managers. Employees are not employees, but are directly performing services for an employer, such as the contractor, the consultants. The example I gave earlier, a piano player in a bar. The employers are not responsible for sexual harassment, are responsible for sexual harassment perpetrated by their employees and non-employees against the others. Employers are also responsible for sexual harassment perpetrated by their employees and non-employees against customers and patrons. Customers, patrons, and third parties as perpetrators of sexual harassment. The Illinois Human Rights Act prohibits sexual harassment of employees, non-employees by customers, patrons, and third parties. Employers are responsible for sexual harassment of their employees and non-employees by customers and patrons. So if you're running a bar and you have customers that are saying inappropriate things to your staff there, they need to be trained to bring this to management and to have them deal with the matter and deal with the customer and their inappropriate actions. That is upon the employer to do that. Otherwise, it can very easily digress into a hostile work environment. Employers are also responsible for sexual harassment of their employees and non-employees by third parties, such as sales representatives, vendors, and/or delivery persons. An example of this would be a UPS driver, a FedEx driver, someone that comes into your facility and interacts with your staff, and they could be one or the other or both. They could be harassing your employees. Your employees could be harassing them, or they could be harassing each other. So it's incumbent for the employer to pay attention to that and keep a lid on that as well. Some other information we're going to cover here, the explanation of sexual harassment consistent with the Act, examples of conduct that may constitute unlawful sexual harassment. That's next up. Sexual harassment includes unwelcome conduct of a sexual nature, sexual advances, requests for sexual favors. Some examples are pressure for sexual favors to go out on a date, deliberate touching, leaning over, or cornering another person. I mentioned this in the manufacturing environment and perhaps even in the office environment when someone is getting too close, violating the personal space. Sexual looks, gestures, or whistling at someone. while in my opinion, one of these does not necessarily constitute um, inappropriate conduct. If it happens routinely, the same person does it all the time, or a same area, if someone from the office walks out into a shop or work area and there's whistling and those types of things, that is unacceptable. I read a case one time where a woman walked by and some guy would just grunt at her, and that was found to have created a hostile work environment. Some other examples of inappropriate conduct are sending letters, telephone calls, emails, texts, voicemails, other material of a sexual nature. That can include, I think, sending inappropriate text messages, memes, those types of things. While some of us may find them funny, it's not acceptable to do that with your coworkers in the workplace there. The sexual teasing, the jokes, the remarks or questions. So many times that starts out just fairly innocently, but yet it seems to digress and ultimately ends up offending someone. So, as an employer, it's best to just try and keep a lid on that. You don't want to be the no fun workplace, but we have our responsibilities to make sure that this conduct doesn't go on. Some terms that again can lead to a hostile work environment: girl, hunk, doll, babe, honey, tootsie, etc. Those types of things. And while they may be well intentioned, um, we've got names. Let's just address each other by names if we feel the need to call someone out. And of course, lastly, actual or attempted rape or sexual assault would certainly be inappropriate conduct. So I was talking about this, that the subtlety can lead to harassment. For this reason, every manager or supervisor and employee needs to remember that those somewhat seemingly harmless and subtle interactions can lead to that. Um, I know people who use these terms, honey, darling, sweetheart, and they don't act like they're trying to be offensive, but it's objectionable to many women, and they believe that these terms really kind of undermine their authority and their ability to deal with men on an equal and professional level. So don't uh, don't use those terms. And while the use of this term by an individual with authority over a female employee will rarely constitute an adverse employment action, it's a piece of the puzzle. It's part of the creation of a hostile work environment. So um, just keep that in mind. Some additional examples of conduct that might be constituted as sexual harassment: turning a work discussion into sexual topics, asking about sexual fantasies, preference, or history, sexual comments, sexual innuendos, sexual stories, uh, about a person's clothing, their body, or looks, kissing sounds, howling, or smacking lips, telling lies or spreading rumors about a person's sex life. People do that, text messaging and things like that too. So whatever methodology you use, it's still inappropriate. And then actually, touching people, massaging their neck, their shoulders, um, their clothing, or their body. Um, we should all refrain from that. That's just that's not a good thing for anybody. While the most commonly recognized forms of sexual harassment include the types of conduct we've described, The non-sexual conduct can also constitute a violation of applicable law when the conduct is directed at the victim because of his or her gender. For example, a female employee who reports to work every day and finds her tools stolen, her station filled with trash, her equipment disabled by male coworkers because they resent having to work with a woman. Almost kind of like a hazing process that where somebody's always playing games with, or they're picking on somebody, or they're trying to initiate them into the process. This is problematic as well. If you get wind of this, it needs to stop. So it's not always about the intent. It can also be just about the impact. Outcomes, not what you meant to have occurred, but it did. So be careful what you say or do in the workplace around coworkers, clients, and vendors. And there are provisions in the law for individuals to be held personally liable and named in a lawsuit. I have not read any cases of this. I'm sure it's out there, and I am sure that it is pretty onerous, that the people are doing just what I might refer to as just stupid stuff, but people continue to do that. So know that you can be named individually, and then if you're a supervisor or a manager and you do nothing to stop it, wrong on that front as well. Sexual harassment in online environments. Our conduct online and through social media can constitute sexual harassment even when it occurs off the clock, off-site, or out of state. Online sexual harassment includes using email, cell phones, text, internet postings, online comments, blog posts, social media, Facebook, Twitter, LinkedIn, Instagram, YouTube, Snapchat, and probably TikTok and any other social media platform out there when you send communications of a sexual nature. Examples include flirting or requesting demands to go on a date, sending inappropriate pictures or videos, including sexually graphic materials. These are, that's the one I was making reference to earlier, the memes. And yeah, don't do that. Using sexual language or comments, including sexually offensive language, and just flat out cyber stalking, just trying to call someone out, trying to intimidate them. Those are all forms of sexual harassment online. Now let's take a look at some of the laws concerning this and the remedies available to the victims. So what should you do if you witness or become aware of unwelcome sexual conduct? These are some things that you need to know. First of all, if it's happening to you, you have the right and you should tell the person to stop. Stop now. I'm uncomfortable with this. Stop sending me these texts, so on and so forth. The initiating and participating person should stop immediately upon the request. If they continue the behavior or retaliate against you because you've asked them to stop, they can be found to have violated the law by engaging in sexual harassment or retaliation. You also have the right to report the sexual harassment. Several reporting options are available. The options you choose may depend upon the nature and severity of the unwelcome conduct of a sexual nature. Persons who report sexual harassment or participate in investigations are protected from retaliation. Essentially, they're covered under what's known as whistleblower statutes. There are several options, but basically there's 4 of them to report this. So you can call the state of Illinois the Sexual Harassment Discrimination Helpline. And you can see the number down there in the lower right-hand corner. You can report it to your employer. And by all means, I would do this anytime and every time. The employer needs to know about this so that they can fix the situation. And you can file charges with the Department of Human Rights or the Equal Opportunity uh, Employment Commission. Um, Probably unless you have a really, really big case, if you try and file it with the EEOC, you're going to get bounced back to the Department of Human Rights, which is local and is probably going to deal with that, unless, of course, it is um, a big, big case that probably turn into some type of class action suit. You guys should have a poster that looks something like this, similar uh, in your facilities or online, available to those people that are working from home or a remote location. Um, if you know someone that has experienced this, please call the hotline. Confidential, and you can make them anonymous. You can also do it online. Um, the officials from the agency will help you navigate this if you need help with that. Again, the same options for, I went the wrong way, my bad. Um, Reporting it to your employer. Um, your supervisor or member of management should be someone that you trust. Only if the supervisor or manager is the one doing the harassing, reporting it to them will do probably little or no good. Uh, Supervisors and other members are responsible for knowing the employee's internal complaint investigation and resolution process. Supervisors can help affect with immediate positive change. Human resources officers can often work with management to investigate and resolve sexual harassment complaints. This option may be preferred if the perpetrator or the sexual harassment is a supervisor or manager. And also, some organizations have a designated sexual harassment reporting officer, and they're established by employers to specifically receive, investigate sexual harassment complaints. You can consult with your employer's policies for specific reporting information. Um, Rogers HR does some HR hotlines for folks. Some people like to contract this out to give that to a third party. Hopefully, that it's easier to contact a third party than someone within your organization. And other organizations also may have more than one person, a couple of people. Sometimes, if the human resource officer happens to be a man, women are not comfortable reporting that to them. So it would make more sense to have a female available as well, in that instance, to have someone to report to, because this is a very sensitive issue, and people can get uncomfortable with that. So a couple things to keep in mind about that. So a reasonable person example, and this is kind of the standard that's going to be used to evaluate some charges. The most severe and overt ones are easy to determine. On the other end of the spectrum, some sexual harassment is more subtle and depends to some extent on perceptions and interpretations of the courts will assess sexual harassment by a standard of what would offend a reasonable person. Um, and remember, the perception and reality story I like is the bank teller was interviewed after being robbed. They asked the bank teller to describe the gun, and he said that the gun had a 6-inch barrel. Well, in reality, it didn't have a 6-inch barrel. It was probably a half inch or 3/4 of an inch. But when that gun was placed in her face, that's the way that she felt, and that's the way that she saw it. So her perception was, in fact, her reality. A charging party alleges that her coworker made repeated unwelcome sexual advances towards her. An investigation discloses that the alleged advances consisted of invitations to join a group of employees who regularly socialize at dinner after work. The coworker's invitations, viewed in that context and from the perspective of a reasonable person, would not have created a hostile work environment and therefore did not constitute sexual harassment. A reasonable person standard also should be applied to more basic determinations whether challenge conduct is of a sexual nature. So in the above example, a reasonable person would not consider the coworker's invasion sexual in nature, and on that basis, there would be no violation to be found. So some tips here. If you feel that you are a victim of sexual harassment, speak up right now. Say something. I'm uncomfortable with your conversation. I wish you would stop. I'm going to report this to the manager, our supervisor. Keep a diary, a log. Nowadays, you can do this on your phone. You can do a voice memo. You can write a little note, or you can put it in a paper or on a tablet. But if you feel this is going down this path, keep a record of it, because now we often forget, how many times did this happen? When did this happen? You can chat with your coworkers. Have they experienced the same thing? Do they feel the same way? Have they noticed this? Have they seen this? All of those things are something that you might want to put in your notes. And then, of course, there's always the formal complaint process to your employer or to the Department of Human Rights. So filing a charge will launch an investigation, which may or may not involve a lawsuit in court. They may file a complaint with the commission if substantial evidence of a violation is found. Complainants who prevail in the Human Rights Commission or court may receive an order awarding remedies allowed by the Illinois Human Rights Commission to make the complainant whole. Remedies can include things like back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement, front pay where reinstatement is not possible, as well as attorney fees. So these things can get very expensive for an employer very quickly. The back pay, if this went back for a ways over 300 days, the person was off pending the outcome of this, benefits and such, this can get very, very expensive very quickly. To file the charge, again, there's the number. You can go to the illinois.gov/DHR. There are offices in Chicago, in Springfield, and in Marion as well. And lastly, the option is to file it with the Equal Employment Opportunity Commission. Again, I think this is probably not something that you're going to want to do. That's going to, you've got a couple limitations here. They can only deal with 15 or more employees. So if it's a small organization, it might not be germane to do that. And you're going to have the same outcome from the Illinois Department of Human Rights. Once the investigation is complete, the complainant may file a suit in federal court. The EEOC may help parties reach a settlement through an informal process called conciliation if the EEOC finds reasonable cause to believe discrimination did occur. That is a less formal process where they'll sit down with the two parties and try and reach resolution. Not all that different than arbitration, but this is just through a government process. Complainants who prevail in federal court may receive an order awarding remedies allowed by Title VII to make the employees whole. Again, it's the same range of things here, from taking documents out of a personnel file, punitive damages, attorney's fees, and costs. As a practical matter, most employees who win reinstatement rarely go back, or if they do, they don't stay long because they were not comfortable with the environment in the first place. But the employer has to allow them to do that. The contact information for the EOC here is several phone numbers, offices in Chicago, as well as in the St. Louis area. And lastly, a kind of a summary of the employer's responsibilities to prevent, to investigate, and to provide corrective measures. Employers are responsible for sexual harassment in two ways. Managers and supervisor harassment employees are strictly liable for sexual harassment perpetrated by members of management, regardless of whether the employer knew of the harassment. And coworker and non-employee harassment employees are liable for sexual harassment perpetrated by an employee, a coworker, or non-employee, a vendor, only if the employer knew or reasonably should have known about the harassment and failed to take prompt action. So as the employer, here again, the key is to make sure that you address this, that you deal with the matter straight up. Employer's responsibility concerning incidents of sexual harassment in the workplace include things like—
Ryan, I think your slides might be frozen or stopped in one place. We're on 57.
Oh my. Yeah, I'm on slide 72.
Okay, yeah. For some reason, it looks like it's frozen. We've been trying to see if it catches up because your voice froze for a little bit too. Maybe try closing it out and opening it back up again.
Yeah, you said 57 is where?
Yes.
You see my desktop now?
No, it is still on slide 57.
Uh-oh, I shut this down.
Uh-oh.
Let me launch this again and see if you still just seeing
Yeah, it says we're viewing your screen, but it doesn't show any slide besides slide 57. If you can't figure it out, we can just continue and then make sure we send the PowerPoint out afterwards.
Yeah, I'm struggling here you can hear me okay though?
Yeah, we can hear you.
Okay.
We're just stuck on one slide.
I apologize for that. I don't know. Well, I'll just go ahead and finish this up here.
Sure, yeah, we're close to the end. We'll just make sure we send out the slides afterwards.
Very good. I apologize for that to everyone out there. I know it's got to be boring listening to me just ramble on here, but employers are responsible in the two ways: the coworker and non-employee harassment, and the employers have a responsibility to prevent the incidents of sexual harassment in the workplace. So that means the training and following up the training. You also need to investigate any incidents of sexual harassment in the workplaces. and then you need to make corrections if there are needed. So in terms of prevention, develop, implement, and regularly communicate to the employees sexual harassment policy, provide training for managers and employees on sexual harassment and prevention, and perhaps more than just this hour that's provided by the state. Sometimes that doesn't get it for everyone, or it's not completely clear. Ensure clear communication on how to report these things. Managers and supervisors should monitor their work environments to make sure it's free of sexual harassment. Supervisors should be aware of the conduct within their supervision. And probably one of the most important, managers and supervisors must lead by example and model appropriate conduct. They have to refrain from engaging in any conduct of a sexual nature. And managers and supervisors should conduct a sexual harassment climate check throughout the year and discuss the topic at team or staff meetings, in service days, or as part of structured communication. The employer's further responsibility to investigate once a complaint is made, interview the complainants, and take reasonable action to protect them from retaliation, experiencing further harassment, interview any relative witnesses, interview the alleged perpetrator of the sexual harassment, and then, of course, document all of the results and maintain a file as an employment record, and then take that corrective action that is needed and appropriate. Take appropriate corrective disciplinary action up to and including termination of the employment where the organizational policy has been violated. In situations where the conduct is in question and did not rise to the level of sexual harassment or violation of policy, but is concerning or may be considered grooming behavior, consider counseling, training, or closer supervision. The employer should also take reasonable action within the organization to reduce the likelihood of future sexual harassment by updating policies, communicating them to the workforce, and providing supplemental or tailored sexual harassment training or restructuring the work environment. And then follow up with the victim at regular intervals to make sure that things are going well and the problem has in fact been corrected. So I'm going to the certificates here now. So you guys will receive documentation on this. I apologize again for the technical glitch here, and we will make this available to you if anybody wants to run through this. So that's kind of the show for today. Haley, did you have any questions, or did anyone have any questions for us?
I didn't see any questions. I did, let me make sure. Yep, no questions. I did just want to mention also that if you are registered under your name and viewed under your name, GoTo will automatically send you a certificate of completion. But otherwise, if you were in the chat or watching in a room with a group of people, you will just receive the DCO compliant form when you have completed this. So keep an eye out for that. And remember, if you were registered under your name and watched under your name, you will receive your certificate. And otherwise, thank you so much. We will see you guys in the next training.
Thank you so much.
Thanks, Dave. Have a good one.
You too. Bye now.
Bye-bye.